gentlelady. We now go to the gentleman from California, Mr. Kiley. 5 minutes.
Good morning. I wanted to get a little better sense of, in the circumstance where an exclusion order is issued, what is the sort of typical response by the infringing entity? And Mr. Corte or Ms. Harrison, if you want to weigh in, I mean, is a license usually the result of that? Do they shift their manufacturing domestically? What's the typical response?
Yes, thank you for the question, Congressman. So the typical response is years more of fighting. So once an exclusion order issues, the company that lost probably has already planned for that, as I mentioned earlier, and has products that things don't fall within the scope of that order. So the next step after a loss at the ITC is to go to Customs and Border Protection, and there's months or years of briefing and argument by lawyers at Customs over the scope of the exclusion order and what products it should apply to. So oftentimes there is no license after a loss at the ITC. There's product changes on the market, and then more fighting at Customs and eventually at the Federal Circuit over what the scope of an exclusion order might actually be.
Well, that part of it seems, problematic to me, and maybe everyone, both sides would agree on that. Professor Doan, what do you think about this issue of fighting it with Customs for years? Is that beneficial to the system?
Well, I don't know about how much fighting there is, but with Customs, I do know that respondents that have lost do try to redesign their products, which, by the way, is kind of the point of a patent, is that if you infringe it, the idea for the patent is that you will then try to design around it and thus advance technology even further by coming up with something different. And the Commission does, in fact, provide respondents with the opportunity to present redesigns to the Commission as well, either during the course of an investigation, if they can get them in on time, or in an advisory opinion proceeding at the Commission. You can say, Commission, I want to import my new product. Here's why I think it doesn't infringe. Will you give me permission? And the Commission can then say yes or no. And if you win, then you are free to import. You don't even have to talk to Customs. It has been blessed by the Commission.
Right. So maybe that's an area where we could focus on reform as well, is sort of streamlining that process so that it would at least set the stage for a better negotiation over a license, or let folks know what kind of alternatives are available to them. Also, when it comes to the consideration of the public interest, I guess, Professor Doan, this would be a good question for you. Do you know in what % of cases an exclusion order is not issued based upon the public interest factors, roughly?
Well, I can tell you the number. If the question is the number that have been denied because of a public interest consideration, I believe there's been actually very few, maybe 4 or 5. But the Commission always does take, particularly in the last 10 to 20 years, has taken public interest not to deny relief, but to modify the scope of relief. They consider it and how they draft the exclusion order, whether particular products are covered, whether to grandfather in already imported products or new products. They do take public interest into consideration to make sure that that there is no harm. For example, this is a trade secret case, not a patent infringement case, but there was a case in which it was found that batteries for electric cars were going to be excluded because they were being produced after theft of trade secrets. But the Commission modified its exclusion order, giving American car companies the opportunity several months before the exclusion order would go into force, to allow them to switch to and design in other types of batteries into their cars so that they wouldn't be using an infringing battery.
So what do you make of this notion that these proceedings are duplicative, because you might have parallel litigation going on in U.S. courts? Is there any validity to that? And from my perspective, it seems that if you're importing a product that may be infringing, then maybe that situation we should have more scrutiny, and perhaps the additional remedy than an exclusion order, which we don't really have now in the U.S. system. What do you make of that argument?
Well, it certainly is the case that one can file a district court complaint with a Section 337 complaint. In fact, I would say it's probably more common than not that is done, largely because the ITC does not have the authority to give money damages. So if you do actually want to get compensation for past infringement, you do have to go to district court to get that. The exclusion order is prospective going forward and removes the product from the market. But there is 28 U.S.C. 1659, I believe is the number, which gives if you are a respondent in an ITC case and a defendant in a district court case, you are automatically entitled to a stay of the district court case until the ITC litigation is completely concluded, including all the way through appeal. So you're not facing two trials at once unless you choose to. You can decide to waive that right, but the statute gives a respondent in that circumstance an absolute right to stay the district court action.
Thank you. Well, I think that there are a number of opportunities for reform to make this process work better, but I think in the process we need to make sure that we're not in any way making it easier for China to infringe on American intellectual property, which seems to be a huge risk here, and also need to be mindful of the impact that weakening the availability of exclusion orders would have on innovation in this country, and in particularly smaller innovators. So I thank the chair for holding this hearing, and I think there's a lot we can work on this going forward. I yield back.
I thank the gentleman. We now go to the gentlelady from San Jose, Ms. Lofgren.
Thanks.